The Ranch Homeowners Group is a private social media community on Nextdoor that is only accessible by the ranch homeowners. The Ranch Homeowners Association is not affiliated with or a member of this private group, and we are not attempting to be misconstrued for being one. This group encourages moral uprightness in our neighborhood. The public can access the YouTube channel to receive future updates on subjects that owners of the ranch homes will wish to follow. Click the subscribe button below.
In 2020, new changes took effect regarding HOA elections in California under California Senate Bill 323 and in Civil Code 5100. There are several changes that every HOA should have implemented this year, and the following is a brief overview. Code text. Civil Code Civ. Division 4. General Provisions, 3274 to 9566. Heading of Division 4 amended by Stats. 1988, CH 160, Sector 16. Part 5. Common Interest Developments, 4000 to 6150. Part 5 added by Stats. 2012, CH 180, Sector 2. Chapter 6. Association Governance, 4800 to 5450. Chapter 6 added by Stats. 2012, CH 180, Sector 2. Article 4. Member Election, 5100 to 5145. Article 4 added by Stats. 2012, CH 180, Sector 2. 5100. F1. Notwithstanding any other law or provision of the governing documents, elections regarding assessments legally requiring a vote, election and removal of directors, amendments to the governing documents, or the grant of exclusive use of common area pursuant to Section 4600 shall be held by secret ballot in accordance with the procedures set forth in this article. 2. An association shall hold an election for a seat on the board of directors in accordance with the procedures set forth in this article at the expiration of the corresponding director's term and at least once every 4 years. B. This article also governs an election on any topic that is expressly identified in the operating rules as being governed by this article. C. The provisions of this article apply to both incorporated and unincorporated associations, notwithstanding any contrary provision of the governing documents. D. The procedures set forth in this article shall apply to votes cast directly by the membership, but do not apply to votes cast by delegates or other elected representatives. E. In the event of a conflict between this article and the provisions of the Nonprofit Mutual Benefit Corporation Law, Part 3, commencing with Section 7110 of Division 2 of Title I of the Corporations Code, relating to elections, the provisions of this article shall prevail. F. Directors shall not be required to be elected pursuant to this article if the governing documents provide that one member from each separate interest is a director. amended by Stats. 2021, CH 517, Sector 1. AB 502, effective January 1, 2022. For HOAs with more than 6,000 members, elections can be settled by votes of acclamation when there are not more candidates than open board seats. This is not possible, however, if your HOA bylaws require votes by ballot. Each HOA must hold an election every 4 years. Many HOAs have terms for board members of 1 or 2 years, so this might not be a big change for many HOAs. Boards can no longer suspend the voting rights of members who are delinquent in their assessment payments. Under the updated law, all members should receive ballots. Property managers cannot fill the role of election inspector. Only members of the HOA are eligible to run for a board seat. Board candidates may be disqualified by the HOA if they were members for less than a year, co-owns a home with another board member, has delinquent assessments, or other disqualifications set by the HOA documents. The election cycle must involve 30 days for nominations and announcements of candidates 30 days before distributing ballots. With time for voting, the election cycle can take 90 days now. There are other procedural requirements under the new law. We are in the year 2022 of the making of this video, and all HOAs should have consulted with an experienced business HOA attorney upon this law enacted. All HOA election policies, rules and procedures should be in place shortly and all information distributed to the HOA membership to ensure that you or we are in compliance with all relevant law measures. SB 323 was implemented effective January 1, 2020. It limits the right of an association's membership to set qualifications for candidates. It prevents non-owners from running for the board and allows associations to disqualify candidates only if they have been owners for less than 1 year, if a joint owner was on the board or a candidate, if they have been convicted of a felony that jeopardizes the association's fidelity bond insurance, or if they were delinquent in assessments. It prohibits associations from ever suspending an owner's right to vote. It requires the inspector of elections to be an entity or individual with no previous contractual relationship with the association, which disqualifies an association's existing managers, attorneys and accountants, among others. This will be a new cost for many associations. It requires associations to post the requirements for running for the board at least 30 days before the nomination deadline. It requires associations to post the list of candidates, deadline for returning ballots, time and place of the annual meeting, all 30 days before ballots are mailed. It allows owners to review the signatures of all other owners on the outside mailing envelopes, and to copy voter lists, including parcel numbers. As a condition of casting a ballot, homeowners must give up their right to keep their signatures private. It makes member email addresses part of the membership list available to all members, upon request. Members can opt out of having their email addresses included with the membership list, but the bill makes no allowance for email addresses that have already been provided to associations. Do your HOA pre-election notices comply? By now, most community associations have at least commenced the process of adopting new election rules in order to comply with the mandate of Senate Bill, SB 323, which took effect on January 1, 2020. This is because, in most cases, adoption of new election rules will require a 28-day member comment period, and the new election rules must be adopted by the board at least 90 days before the association's annual election. Adoption of new election rules, however, is only the first step in complying with the new requirements imposed by SB 323. Once new election rules are in place, an association will need to comply with a host of new statutory notice requirements and deadlines commencing at least 90 days before a board election. Call for candidates. Most associations are accustomed to sending out a call for candidates in anticipation of an annual meeting. SB 323, however, imposes requirements on what information must be included in the call for candidates and how long the nomination period must remain open. Specially, SB 323 requires that an association must provide general notice of the procedure and deadline for submitting a nomination at least 30 days before any nomination deadline. This means that any call for candidates must be issued at least 30 days before the deadline for submitting nominations and must explain the procedure for submitting a nomination. This explanation should, at minimum, include whether the use of any prescribed form is required, where said form can be obtained, and where, how, and by when it must be returned. Please note that it is not necessary for the association to distribute the nomination form to each member, so long as it gives general notice of all the information contained above at least 30 days before the nomination deadline. General notice may be given by mailing or by posting in the location within the common area designated for the giving of notices in the annual policy statement distributed to members. Individual delivery is required for any member who has requested individual delivery of notices. Pre-election 60-day disclosure. Following the close of candidates, and, ideally, after the association has completed IDR with any disqualified candidates so requesting, the association is required to give general notice of certain information at least 30 days before ballots are distributed. Because ballots must be distributed at least 30 days before an election, this notice must be given at least 60 days before the election. If ballots are mailed out sooner, however, the pre-election notice will need to be given earlier. The pre-election notice must include all of the following: 1. The date and time by which, and the physical address where, ballots are to be returned by mail or handed to the Inspector of Elections. 2. The date, time, and location of the meeting at which ballots will be counted. And 3. The list of all candidates' names that will appear on the ballot. Like above, if any member has requested individual delivery of all general notices, the association will need to provide individual delivery, example, mailing, of the pre-election notice to the requesting member. Election rules. In addition to ballots, SB 323 now requires that a copy of the election operating rules be delivered to every member at least 30 days before an election. Delivery of the election operating rules may be accomplished by either enclosing the election rules with the ballot distributed by individual delivery, or by posting the election rules to an internet website and printing the corresponding internet website address on the ballot together with the phrase, in at least 12-point font.